The only people who don't want to disclose the truth are people with something to hide.
Mario, it's great to be back with you again. This is Chuck Kuck and Rocky Rockcliffe on America's Web Radio, the Immigration Hour. Mario, in case you didn't know it, Rocky and I are both actually immigration lawyers.
I know you were right. I wasn't sure about Rocky.
Yeah, we're both immigration lawyers. We practice immigration law full-time. I also teach at the University of Georgia Law School, teach the immigration law class. And I'm actually going to incorporate this into my next class because I think it's absolutely fascinating discussion.
Fascinating.
What this means. And we were talking on the break that I didn't really buy the whole thing that McCain is eligible as well. Rocky's, you guys have kind of convinced me. I'm still think, dude was born in Panama, man. I'm sorry. I don't care what his parents were doing. But I get it. But now, Robert, before you go further, you keep referencing Vattel or Rotel. Can you tell us who you're talking about, the law of nations? What is that?
Yeah. Emir de Vattel, V-A-T-T-E-L. He wrote a treatise in 1758, which was written in French. Now, Vattel was Swiss, and basically he took all the natural law ideas that had been coming, ever since the Roman Empire, and just moved it forward, and he applied it to the affairs of nations. And when you do that, you produce the law of nations. And the founding fathers, they read Vattel religiously, even to the point where George Washington had his treatise read on his desk, the first day of his presidency. Congress had it as they were, creating the new nation. His books were like, so coveted. Being sent from Europe, and who got this and who got that. It was very, very tremendous source to have, and many of the ideas. If you look in there, free and independent states. It's there's so many ideas in that treatise that were incorporated into the making of the United States, and in there he defines who the natural-born citizens are.
Now, I do have to say,
in Section 212.
People have complained about the Supreme Court citing foreign law recently in some of their decisions. So isn't it controversial to look at a French dude's interpretation of what the law is?
No, absolutely not. First of all, the founders did not consider the law of nations as foreign law.
Okay.
It's not like later on we use the word international law.
Right.
They didn't have that word then. They didn't use that. They called it the law of nations. The law of nations was based on reason. Okay, they considered it as coming almost from God. If you look at the Declaration of Independence, Thomas Jefferson talks about the law, the law of nature and nature's God. That's where the law of nations comes from, because it comes from natural law.
Okay.
These were ideas that the founders believed in, and it was immutable. Immutable. You couldn't change it. It was good for all times. It was good for all civilized nations. It was not like today where we say, oh, that's French law, that's English law, that's Italian law, whatever. Nothing like that. They had a tremendous respect for it. Now, also remember, there was no other law in the new America. You had the English common law, which only applied to the states. The national government had no other law, so they looked to the law of nations for their foreign affairs, for treaties, rules of war. Prizes, and Chief Justice John Marshall in the Venus, 1814. He cites Vattel and defines the natural-born citizen. Although he used the word indigenous, because Vattel in the beginning was interpreted to say the natives or the indigenous. Okay. But I have a whole writing on that about what that means and how it means natural-born citizen. Because later on, the Supreme Court says natives or natural-born citizens.
Well, let me ask you this question. So the 1790 Act gets overturned and repealed in 1795.
Yes.
Why? Why did 5 years? Well, I mean.
Yeah. Well, because things were heating up. Things were heating up. There was a lot of. It's exactly what I was saying before about more people coming over from Europe. Mm-hmm. You had the French situation. And the founders, the leaders, they were getting a little nervous that we're getting infected, so to speak, quote unquote infected by all these foreign ideas. So they just made it harder to become a citizen.
Okay.
And James Madison. Now going back to your question about James Madison, mm-hmm. he's a congressman at that point in 1795. His committee gets together and they say, something. if you're born out of the United States, you're not a natural-born citizen. You're a citizen of the United States. And that's fascinating. This is James Madison.
Because it's Section 3 of 1795 of the 1795 Act, which talks about what we're talking about. Ignore the other sections. It's just about naturalization. It says the children of duly naturalized, dwelling within the United States, being under the age of 21, time naturalization, and children of citizens of the United States, born out of the limits and jurisdiction, shall be considered, quote, citizens of the United States, which is different from the natural born, which they had in the Act of 1790. Then they talk about, provided that the right of citizenship shall not descend to persons whose fathers have never been resident in the United States. So it really eliminated jus sanguinis, didn't it, as part of that process?
That's right. Now, it didn't eliminate it. It still granted it to be a citizen. But Congress is saying, look, you can't be a natural-born citizen if you're born out of the United States. Right. Now, that's very important because if you go back to Article 2, which we started our discussion with, it clearly makes a distinction between a citizen of the United States and a natural-born citizen. So what that means is this, that if you're not a natural-born citizen, you're out of luck unless you're one of the old-timers.
Right.
You got to be grandfathered in under Article 2, which today, of course, is an impossibility because everybody's died off who was born before the adoption of the Constitution.
Or so we think. Just kidding. You haven't met David, have you? Just kidding.
Yeah, so you see how this all fits together? It's a tremendous puzzle that all fits together very neatly and very logically.
So here's the question then. We then have, let's say, 170 years of Supreme Court cases, not very many, but going back 170 years, where they basically ignore Vattel.
Well, no, absolutely not.
So why haven't they come to the same conclusion, for example, in King Monarch? Because they were talking about a different issue.
Yes, it was a different issue. See, what happens then is we know what a natural-born citizen is, right? But then we're arguing. We're arguing and arguing. What's a citizen? What's a citizen? We got to know what a citizen is. Okay, we know what a natural-born citizen is, and then that's where the political battles come in. Who's a citizen? And the problem there is again, Congress for the first time in 1866, 1866 Civil Rights Act says, okay, if you're born in America and not subject to a foreign power, now that's a powerful statement.
Right.
That is a powerful statement. That tells you right there we can't be following the English common law because under jus soli, your parents were foreigners and they made you a subject of the kingdom. You had all kinds of conflicted allegiances. Your father could have been French, your mother was English. Let's say your father's French, your mother's German, and you're born in the Kingdom of England. You got three nationalities.
Right.
So.
And I think that's a good point about the whole idea of no foreign allegiance or foreign powers.
Yeah.
Because that clearly applied from the research I've done on this issue. If your parents were diplomats in the United States. So if you're principally born in the United States and your parents owe a foreign allegiance because they were diplomats, not because they were citizens of a different country.
There's an exception to the English common law.
Right.
If your parents were, diplomats or invading armies.
Right.
Yeah. So there's an exception. The king said, "Okay, no, we're not going to indoctrinate you, so to speak.
Right.
We'll let you go."
And that's still the case today. If you are born in the United States and your parents are diplomats, you are not a U.S. citizen.
Supposedly, yes. I don't know whether they're applying that.
No, they are. They are. You are only a permanent resident of the United States.
Yes, that's correct.
And that's the rule. And there was even a terrorist guy who had that happen to him that they ended up catching or bombing or something back shortly after 9/11. He was born here, but he wasn't a citizen because his parents were diplomats.
And that's because of the jurisdiction clause.
Correct.
Not you got to be subject to the
jurisdiction thereof. Right.
But again, we're talking about citizens now.
Right.
You see? We're not talking about natural-born citizens.
Right.
See, like we started earlier, we said, look, when they wrote the Constitution, every word was important.
Correct.
Which I want to tell you this very quickly. The word is natural-born citizen. It's not born citizen. You see?
Yep.
So we have this Jack Maskell. Have you seen that yet?
I have.
Okay.
He
argues that and I just wrote a piece on that.
I know you did. That's why we're having the conversation today.
Yeah. And clearly, I'm convinced that both his his one argument is, well, wait a minute. If you're a natural-born citizen, then you're a citizen at birth, right? That's correct. Then he says, well, you know something? Anybody who's a citizen at birth is therefore a natural-born citizen. No, 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 no. Invalid. Invalid, okay?
Well, doesn't that go along the logic of I'm a man, all men die, therefore I will die, or Socrates, or whatever?
Yeah. Well, we can. But again, I mean, I've explained it on my blog. You can't say that since all the natural-born citizens are citizens at birth, so therefore, if this guy's a citizen at birth, he's a natural-born citizen. That's an invalid argument. There's logical. It's a violation of the rule of the undistributed middle. It's affirming the consequent. Those are logical
arguments, right?
Things, Okay, but then let's go further. Let's go further and say, wait a minute. Let's recraft Mr. Maskell's argument. Let's say that all born citizens are natural-born citizens. Okay? Now, if you argue from that, then you say, oh, Jack's a citizen at birth, therefore, Jack's a natural-born citizen. That's illogical. It's valid, but it's unsound. Why is it unsound? Because the first premise is false. There's no evidence that all born citizens are natural-born citizens. There's no evidence of that whatsoever.
Now, isn't it fascinating that we're having this discussion 230 years after the Constitution, and this has really not come up in any presidential elections till now?
Yeah.
I mean, this is fascinating. How did we avoid this because one thing I really appreciate you did in your blog, because what Maskell says is the Supreme Court hasn't addressed the issue of natural-born citizen, and I know that's not true. Anybody who's got LexisNexis can find the Supreme Court addressing the issue of natural-born citizen, not necessarily in the presidential election context.
I think that's what's important here, though, is in the context of presidential election, because in the other context that they address it in, it's for purposes of any other substantive right apart from running for president, so they don't address it as in this vein of whether somebody's eligible for presidency.
But does the wording natural-born citizen mean something different in a different context?
Right, very good. Yeah, I say no.
Yeah.
Yeah, how could it? I mean, it's a constitutional word. It's a word of art. It's an idiom. It's a unitary clause. And it only applies to the unique president of the United States. It's a unique office. It's a singular. See, that's very important. Singular. See, that's why the founder says, "Oh, wait a minute. This guy, or gal today, right? It's a singular office, very powerful, civil and military. He can destroy your whole nation." So they said, no, it's got to be a natural-born citizen. Oh, okay, Congressman, that's a collegial body. You got a lot of people there that can keep this guy in check, in case he's running wild or something, But the president is just one guy.
So here's a question for you. We're going to take a break here in a second, but here's a question I want you to ponder while we're gone. Probably the most recent Supreme Court case on this was Wong Kim Ark. I have not found any case in the 20th or 21st century on this issue yet, coming out of the Supreme Court. Wong Kim Ark was really a case about citizenship for Wong Kim Ark and other Chinese nationals born in the United States who we were trying to expel through the Chinese Exclusion Act. Does that have any relevance today as we're talking about who can today run for president? Think about that, Mara. We'll be back in just a second on America's Web Radio.
The only people who don't want to disclose the truth are people with something to hide.